Okay, welcome back. Our next panel is on insider trading. And who better to moderate the insider trading panel than Russell G. Ryan himself? Russ is uniquely qualified, having served both as an assistant director in the SEC's enforcement division and as a deputy director of enforcement at FINRA. He is a real thought leader in the securities enforcement field. If you read the Wall Street Journal, you've probably seen Russ's editorials. I also urge you to connect with Russ on LinkedIn. He has a series of articles that he produces on LinkedIn that are terrific. So you can follow him there and get a lot of great information there too. But always a pleasure to see my friend Russ Ryan. Welcome, Russ.
Thanks, Bruce. Glad to be back.
I also would like to introduce Jennifer Lee from the SEC, where she's an assistant regional director for enforcement in the San Francisco regional office. At the SEC, Jennifer supervises the very insider trading investigations and cases we'll be discussing today. So she is exactly who we need on this panel. Jennifer, welcome. It's great to see you.
Thanks so much.
Very pleased to introduce Erica Williams, who is a partner at Kirkland and Ellis. And Erica brings a really unique combination of experience to this panel. She served at the SEC for 11 years and was deputy chief of staff for 3 chairmen. That role, of course, includes evaluating, providing legal advice on recommendations from the Division of Enforcement. Earlier in her career, she served as assistant chief litigation counsel in the Enforcement Division's trial unit. And prior to that, was a special assistant and associate counsel to President Barack Obama, where she advised the president and his senior advisors on legal issues, including financial regulation and reform. Other than that, not too much experience. I'm just kidding. We are very, very fortunate and grateful to have Erica with us. Welcome, Erica.
Thanks, Bruce. Happy to be here.
Finally, let me introduce Tom Zaccaro. Tom is a partner at Paul Hastings and based in the firm's Los Angeles office. Earlier in his career, Tom was chief trial counsel of the SEC's Pacific Regional Office, where he was responsible for the management and supervision of all the enforcement litigation in the Pacific region. Tom also served as an AUSA for the Southern District of New York and as a trial attorney at the DOJ in the organized crime and racketeering section. So great to have Tom with us. Perfect fit for this panel. Welcome, Tom.
Thank you, Bruce. Appreciate the introduction.
Thank you. And Russ, it's all yours.
All right. Thanks, Bruce. Let's get started. And what better way than to ask Jennifer to give us a brief summary and overview of what the Commission's been up to in the insider trading area, which has, of course, been a mainstay of the SEC's enforcement program for decades now. And Jennifer, why don't you get us started?
Sure. Thanks, Russ. And I know it's late in the day, but first let me give my disclaimer, which is the statements I express today are solely my own and do not reflect those of anyone else at the Commission. And with that, I'm happy to kick things off with an overview of enforcement cases from the last year and a preview of cases in the pipeline. And I think with respect to cases, it's fair to say it's pretty much been business as usual in insider trading enforcement. Over the last 12 months, we filed numerous cases involving all types of players, ranging from board members and C-suite executives down to consultants and contractors. And these cases involve the types of market-moving events that you would expect from our program, including deals, mergers, acquisitions, earnings announcements. We also continued filing additional settlements and high-profile insider trading litigations, including the Newswire hacking case, the Edgar hacking case, and the Stewart insider trading case involving a father and son trading on numerous deals. There is one case that I want to specifically highlight from our office that we filed last year, and that's the Amazon case. So in September, our office filed an insider trading case against an Amazon finance manager, her husband, and her father-in-law, alleging that the husband and father-in-law traded on the basis of tips from the finance manager in advance of 11 earnings announcements. The family in total made over $1 million in profits, and the U.S. Attorney's Office in Seattle also filed parallel charges against the husband, who pled guilty last year. And the Amazon case is interesting on its own, but also fits into a broader trend that I'm seeing, which is serial trading cases involving lower level to mid-level insiders ahead of earnings announcements, particularly at tech companies. And I've seen a couple of these cases percolate over the years, but I'm definitely seeing an uptick in these types of investigations that are ongoing. And for what it's worth, I think there are a couple of dynamics underlying this trend. So one, in the cases that I'm seeing, there seems to be just broadened access to sensitive data to larger groups of people beyond what you would normally expect by way of C-suite executives and finance and accounting folks. So particularly at tech companies, I'm seeing in investigations just lots of data relevant to revenue without robust restrictions and access being opened up to just larger groups of people. And I think it makes sense to the extent that data becomes more electronic. You just need more people like IT administrators and software engineers to maintain that data. But then there's more risk that those people and their associates will trade. I think a second aspect to this is that tech companies, particularly younger companies that have recently gone public, just may have more volatility in terms of their quarterly revenue. And so possibly there's more opportunities for those kinds of employees and their associates to capitalize on inside information. And then finally, I've got to give a shout out to our enhanced detection. As all of you know, our program is very focused on data. And I do think we've been doing a better job in terms of just linking together traders and announcements and events. Even if in the past those dollar amounts might have been slow, it's just easier for us to make those connections. And then the final theme I want to emphasize is increased parallel criminal activity in terms of investigations in this space. All of the cases I mentioned so far have some kind of criminal investigation, and most of the cases that I work on also have that as well.
Thanks, Jennifer. If you look at the annual enforcement reports and some of the reporting, it does look like insider trading cases, at least in raw numbers, have been down over the past 2 or 3 years. And by, not an insignificant amount, but I suspect that's not due to any design or reduction in focus, but, is there a reason for it, or can you just comment on, what might be going on there?
No, I know exactly what you're talking about. And I think it's fair to say insider trading is still a priority for enforcement. We try to cover the waterfront. It still comprises just anecdotally 30 to 50% of what I do. I do think, can we really look at this last year and say, is this indicative of, how enforcement is going to think about insider trading going forward? I think all of us can say our work just, things just take longer, I think, in this environment. But I will also say that insider trading cases are unique in the sense that there may not be smoking gun documents, and it is more reliant on developing cooperators or witnesses or just things where those sorts of things take time. So it's not that the cases aren't there, they just may be perceived as slower in the pipeline than what you might expect.
Erica, Tom, any reaction or questions for Jennifer on this?
Sure, I'll jump in. I appreciated the response because we do hear on this side that the cases are down, but I know the DNA of the enforcement attorney is to bring as many big cases as they possibly can. And of course, insider trading has always been a focus. I did want to know if you could say a little bit more about the data analytics. When I was at the commission, I do know that the staff had really made advancements in linking up phone records and bank records and that type of thing. But I was just wondering, I haven't been there in about 5 years, if you could talk a little bit about the advancements there, since you mentioned that was a focus.
For sure. I think it's that market abuse, which I'm sure you know, Erica, had already developed so many market data analytics, I think even in the time that you were there. And I think what is amazing is not only have they built on that, but I also think the ground level staff has just become much more comfortable with those programs. So it really isn't just, a siloed effort where maybe people were sending off referrals. It's really every staff member has become much more sophisticated in using those tools.
When doing insider trading training, I always tell my clients about that as a warning.
And Tom, let's get you in on this.
Jennifer, I'm not sure you can comment on this, but has the Lau case affected the SEC's approach to calculating disgorgement in insider trading cases?
I love that you probably can't comment on it. No, kidding aside, I think, every time a Supreme Court decision comes out, I think it's a good moment for people to reflect. And all I can say at this point is that there is a clear path in terms of the penalty statute where you can get things, whether it's 3x in terms of profits gained or losses avoided. So for now, I can say that is something that we know we can do.
Yeah, I've definitely noticed that. It looks like whereas you used to have 1+1, disgorgement plus an equal penalty, it does seem like you see a lot more no disgorgement but 2 times penalty. So you sort of get to the same result, but through different means, I guess.
And we'll see. We have a new chair, so TBD in terms of where things go from here.
Yeah, and you have a new statute too, with where Congress has explicitly given you disgorgement authority. I don't know if that's sort of been baked into the program yet. Is there anything you can tell us about that?
Now this is really becoming hot topics, Ross. I can't comment on. This is what I know we can do. Where things are going to go from here, I don't know.
Okay. Well, why don't we shift gears a little bit? And, in insider trading, the law is, to say the least, a bit murky on various elements and ever changing, it seems like. Maybe none more than the personal benefit test that dates back to the Dirks case back in 1983. Tom, can you just start us off with a little bit of a summary and where we are on the personal benefit test? I tend to lose track of what the latest cases say on this, so it might be good to get a refresher.
Yeah, absolutely. And this is probably one of the more dynamic portions of the law to be charitable in insider trading. But I'll just very quickly trace the line of analysis that started with Dirks and went through with Salmon at the Supreme Court and then the Second Circuit in Martoma. But Dirks started out with the premise that tipper liability should be premised on a breach of duty by the tipper, breach of duty to the corporation shareholders. And the Supreme Court in Dirks said that breach of duty is determined by the personal benefit a tipper may gain from the use of the company's information. And that has been known as the personal benefit test. In Dirks, the court said, while not being exhaustive, said the personal benefit can be shown in a number of ways. It could be the exchange of information for some pecuniary gain. It can be a gift to a relative or friend, or it can be an intention to benefit the tippee. So it gave a list of potential scenarios which would satisfy the personal benefit test. The most recent, the first case in a string of cases which focused on personal benefit was U.S. versus Newman, a Second Circuit case where the case dealt with remote tippees who were several steps removed from the original tipper. And the court narrowed the personal benefit test to say that to show a personal benefit, the government must show, I just want to look at my notes to get it correctly, a proof of a meaningfully close relationship that suggests the exchange of a potential gain of pecuniary value. So the court did two things. One, it defined that the relationship between the tipper and tippee has to be meaningful enough to suggest that the exchange of information will lead to some financial benefit. The next case in the line was U.S. or Salmon versus U.S. It was a appeal of a Ninth Circuit decision, and the Supreme Court in that case said that Newman was too restrictive and too narrow an interpretation of Dirks, and said, the government need not show a pecuniary gain. As long as it showed the other elements of Dirks, either a gift to a trading relative or friend, or one of the other elements of Dirks, it was sufficient without showing some financial gain or promise of financial gain. What Salmon didn't address is the portion of Newman that talked about the closeness of the relationship between the tipper and tippee and how close it needs to be in order for there to be tipper liability. The Second Circuit had a chance to address that issue in Martoma, U.S. versus Martoma, which came out a few months after Salmon. And essentially, Martoma, in the first go-around, the Second Circuit said Newman did misinterpret Dirks, that Salmon essentially overruled Newman. And in Martoma, the court said there does not need to be a close relationship between the tipper and tippee liability to show personal benefit. That so long as the tipper is intending to give a benefit to the tippee, that would be enough to satisfy the test. And the court talked about something which is common in New York, and that is having doormen at your apartment building and said, the intention of gifting or giving a benefit to your doorman by giving him or her confidential information is enough to show a personal benefit, even if you don't have a close relationship with that doorman. The decision was 2-1. The defendant, Martoma, sought en banc review, and before, which was accepted, but before there was an en banc brief submitted, the Second Circuit issued an amended opinion, or Martoma 2, which basically said, confirmed that the Newman test of a meaningfully close relationship was dead. The government need not show that type of relationship between the tipper and tippee, and that the personal benefit test could be satisfied in one of three ways, either focusing on the language in Dirks. One, a gift by the tipper and the tippee. Two, a relationship which suggests a pecuniary gain or potential for pecuniary gain, but didn't address or suggested that the Newman test was no longer valid. And thirdly, an intent to benefit the recipient of the confidential information. So three ways to satisfy the test, much broader than Newman, probably even broader than Dirks and Salmon. Of course, Martoma only applies in the Second Circuit. Not many other circuits have addressed it, but for now, we have a very broad definition of the personal benefit test, at least in the Second Circuit, and no clear guidance as to whether there needs to be a relationship, and if so, how close that relationship needs to be in order to constitute a personal benefit. And that's where we are currently in the state of the law.
All right. Jennifer, there's all this back and forth. There's all this back and forth hair splitting really affect the day-to-day insider trading program at the commission. It comes up rarely. When it does, it's a big deal. But just how important is this personal benefit test to the SEC's program?
I suspect by your question, you already know the answer, which is, I think personal benefit really is not going to be an issue in most cases. And I think, as Tom said, they're really going to fit into two categories. Either it's going to be the gift theory to a trading relative or a friend, or it's going to be the quid pro quo, let's say the Martoma type situation. And in most ring cases, which, those are a lot of our cases involving just everyday sort of traders, the non-analyst people, there will usually be some kind of friendship or relationship between the tipper and the tippee. So it really is not going to be an issue. I think on the quid pro quo side, the Gupta case basically says you don't even need to really identify some specific quo for a quid. It can really just be some sort of ongoing business relationship. And in practical terms, what that means for me is I just look for any kind of financial relationship. And I think about just, are there any kind of shared assets, fee arrangements or leases, loans, cash transfers, unusual purchases or trips that the two have taken together, things like that. So in most cases, the case is going to resolve one way or the other. And I would say, especially post-Salman, I just don't think personal benefit is really going to be litigated that much, since it is pretty flat. is trading friend or relative without regard to how close that relationship has to be.
Okay, any thoughts on this, where you think this may go next? What's the next big thing, to quote Bruce's thing here?
Yeah, no, I agree with Jennifer that as a practical matter, it doesn't really have any impact. But I will say that in the legislation that was proposed and passed the House, that was proposed back in 2019 and passed the House, one of the amendments to that bill that Congressman McHenry proposed was one that would add language requiring evidence of personal benefit. Originally, the bill did not have that language. Ironically, once it passed, it had that language and the language getting rid of personal benefit, which if it had, passed the Senate, likely would have led courts to interpret that personal benefit proof was required. So one area that you may see is if Congress decides to take up insider trading, that may be an area that they focus on, is the personal benefit test. It's no telling how that may come out. But that is the only thing that I could predict that may happen in the future.
Okay, thanks. Sticking with you, Erica, let's talk about two recent insider trading policies and procedures cases. One is the Ellis management case and the Endeavor case. They're different, but I tend to think of them the same because they focus more on policies and procedures than actual insider trading. Can you give us a little bit of background on that?
Happy to discuss both of them. I'll start with the Endeavor case. And just to provide some background, in October 2020, the SEC announced a settlement of charges against Endeavor for alleged controls violations relating to a stock buyback plan that the company implemented while it was in discussions to be acquired by Marathon Petroleum. And this is back in 2018. According to the order, Endeavor and Marathon had held months of confidential discussions in 2017 about Marathon potentially acquiring Endeavor, which was at the time was an energy company headquartered in San Antonio. The order found that in October of 2017, Endeavor's then chairman agreed to suspend discussions. And then in late January of 2018, they resumed talks. And then in February, Endeavor's CEO directed the company's CFO to reinitiate a 10b5-1 plan to repurchase $250 million of Endeavor shares. The next day, the legal department approved that 10b5-1 share buyback plan. And then the day after that, Endeavor began repurchasing its stock on the open market. Ultimately, it repurchased 2.6 million shares of its stock at an average price of $97 per share. So what the SEC order found was that Endeavor used what they called abbreviated and informal processes to determine whether or not the requirements for the buyback were satisfied, including whether or not the company was in possession of material non-public information. And it finds specifically that the process that the company went through for evaluating whether or not the potential acquisition was material was not adequate. They said they didn't have internal accounting controls that provided reasonable assurance that the buyback would be executed in accordance with the board's authorization. And so as a result, they charged Endeavor with violations of 13b2b of the Securities Exchange Act, which requires a company to devise and maintain effective internal accounting controls. And Endeavor settled without admitting or denying wrongdoing and agreed to pay a $20 million civil penalty. So just reading the case, not having any additional information, my suspicion is that the investigation probably started out as an insider trading investigation, but ended up as an internal controls violation case. And it really does raise some interesting questions. First question that I thought was interesting is it appropriate to read 13b2b to cover policies related to trading? And so it's worth noting that Republican commissioners Peirce and Roisman issued a public statement expressing their views on the case, and that's relatively rare for an enforcement matter. And their views in that statement made it clear that they were not in support of the 13B2B charge. They noted that since the inception of 13B2B in 1977, the commission had never before found that internal accounting controls required by that provision include management's controls over assessment of the company's potential insider trading liability. And they also took issue with casting 13B2B as a generic internal controls provision. What they said was that it really was about internal accounting controls, and they really questioned whether or not insider trading controls and processes were internal accounting controls. And they specifically said they didn't believe that that particular reg was intended to address insider trading. They did, however, note, and this is another interesting point, that Endeavor's processes could have been better and that they left substantial room for improvement. And so there is a potential, if your processes are not, for evaluating insider trading are not adequate, that a 10B5 charge, a 10B and 10B5 charge could be potential liability depending on the facts and circumstances. So the key takeaways for me from this case is it just highlights the needs for companies, public companies, to evaluate their internal corporate governance policies and procedures, and in particular, to ensure that the company's not in possession of MMPI when it decides to trade or when implementing a 10B5-1 plan, including stock repurchase programs. And that assessment needs to include discussions with executives who may be engaged in potential mergers and acquisition discussions. Then I can move on quickly to Ares. So in Ares, May 26, 2020, Ares agreed to settle claims with the SEC and pay $1 million penalty. The SEC alleged that the firm failed to implement and enforce its policies and procedures related to preventing misuse of material non-public information. And what they found was there was a member of the deal team when it that sat on portfolio company boards, public portfolio company boards, and that Ares did not take adequate efforts to implement their procedures to make sure that those deal team members didn't have MMPI. This is interesting because the SEC brought this case even though all of the trading that occurred here occurred when the portfolio company's trading window was open. So that sort of suggests that the Portco did not believe that its officers and directors were in possession of MMPI. And there were no insider trading claims filed here either. So the SEC didn't find that any insider trading occurred. But they did acknowledge that also that Ares had placed the portfolio company on its restricted list, and that compliance staff at Ares had confirmed that the trading window was open. But they did find numerous instances of what the staff found was insufficient documentation, that the compliance staff did not document the discussions that they had with the deal team related to MMPI. From my perspective as defense counsel, I really do think this case has taken the private equity industry by storm, and that as a result, private equity firms now are implementing compliance procedures that require this documentation. Notwithstanding the fact that as in Ares, they were having these communications with the deal teams, I think that after this case, most, if not all of them, probably took a look and said, you know what, we need to make sure that our procedures require written confirmation of these discussions. So takeaway from this one for private equity managers, it is important to confirm in writing the policies and procedures that require this compliance staff to talk to the deal team and confirm there's no MMPI, and to investigate trading approvals in those particular deals that may present a heightened risk of MMPI.
Okay, Jennifer, can you give us a little perspective from the staff side? What's the message from these cases? And should we be looking for more of the same coming down the road, or are these just cases that, you take them as you find them?
No, thanks so much, Russ. And Erica, I'm so happy to hear that private equity firms are being more proactive in terms of thinking about their controls, because especially for regulated entities, as you guys all know, there are specific statutes that require registered investment advisors and broker dealers to have written policies and procedures in place that are reasonably designed to prevent the misuse of material non-public information. And I think some of the cases that we brought in this space are ones where the fact pattern just identifies some sort of transaction or relationship that would raise eyebrows. And I think the Aries case is one where you've got an employee from the firm that is now going to be an insider who is still participating in trading decisions by the firm. So it's this question of just, are firms really thinking proactively about their insider trading policies when it comes to affiliates, commonly controlled entities? I think the Deerfield case is another example where the firm basically relied on its employees to self-report insider trading. Emails suggested that its analysts might be receiving inside information, but no one self-reported, and instead the firm ended up placing really profitable trades for certain of its hedge funds on the basis of that information. So again, it's this, sort of sitting back and not really thinking about whether your policies are really designed for your business. And so ultimately, I think the takeaway is, don't have the insider trading policy be sort of this afterthought when you're going through corporate transactions, thinking about relationship, things like that. So I'll just circle back to Erica, that I'm so glad to hear that you guys are being more proactive.
Tom, how about you? What are you seeing, and what are you advising in light of these cases?
I think I agree with everything Erica and Jennifer said. I mean, it has been a jolt to private equity and other regulated entities when they seek advice. We obviously tell them they need to have all the procedures in place to ensure that they're running all the insider trading traps they need to run before they can make a trade. In the Endeavor case, I think it's unusual. It's an unusual fact pattern that the company is just buying back its stock at a time when it may have material non-public information. I haven't encountered that issue that frequently. Most companies limit when they can buy back their own stock, but it's certainly advice we need to start giving companies when they consider a stock buyback plan. What we always get asked, and Jennifer, maybe you can respond to this, is when a company has received a FINRA letter or an SEC subpoena, and for one of their employees who is under the microscope and may have engaged in insider trading, the company says, well, what does that mean for us? And I'm not aware of any SEC case with that fact pattern where the company was charged as opposed to the individual employee. But I'm curious, are you aware of any SEC case where a company was charged for an employee's insider trading? And if so, why?
I think it depends. I'm not aware of one. If we're talking about issuers, I'm not aware of one off the top of my head, but if the employee is, acting in their capacity for a registered entity, then it's possible that there's something, some of the cases I've just mentioned, I think, have that aspect.
Okay, well, if I'm moderating an insider trading panel, I'm definitely not going to not talk about one of my favorite cases, even though I can't even pronounce it, much less spell it. But that's the Bladecheck case out of the Second Circuit. I'm going to give you the honors of getting us up to date on that case, because I think it's a really important one.
Yeah. And Russ, to be clear, it's a criminal case, so it's not going to affect any SEC enforcement cases, but it could have a significant impact in the criminal arena. So Bladecheck involved an insider trading conviction in the Southern District of New York of several people who traded based upon confidential government information about potential changes in Medicare and Medicaid rates. They were convicted. They were charged under Section 10B with securities fraud, as well as under Title 18 mail fraud and securities fraud under Title 18, which is I think Section 1348. That section was part of Sarbanes-Oxley, and it was intended to avoid all the stuff we talked about earlier about personal benefit and all the other nuances of insider trading under Section 10B. In Sarbanes-Oxley, Congress passed Section 1348, which basically says it's a crime to engage in securities fraud. The issue that arose in Bladecheck is, even though the statute doesn't talk about a personal benefit, although either does Section 10B, but even though it doesn't talk about that, should the court use that standard in a Section 1348 case? Here, the district court, over the defendant's objection, didn't instruct the jury that they needed to find a personal benefit for the Title 18 charge. So the jury comes back, acquits on the Section 10B charge, but convicts on the mail fraud and the securities fraud under Title 18. Goes up to the Second Circuit. The Second Circuit says, look, it essentially affirms the convictions and says that the personal benefit test is not necessary, not part of a Section 1348 charge under Title 18, and that the property interest, confidential government property, is sufficient to satisfy the property standard for the criminal fraud statutes. While that case was pending, so that the defendants appealed to the Supreme Court. Before the Supreme Court heard the petition, it decided Kelly versus U.S., which has nothing to do with securities fraud. It is the Bridgegate case, the case in which, as you people may know, it was the case involving several officials of former New Jersey Governor Christie's staff who slowed down traffic on the New Jersey end of the George Washington Bridge to punish the mayor of the town on that side because he didn't support Governor Christie's gubernatorial bid. So it was pure political retribution. They were convicted below, went up to the Supreme Court and the Supreme Court said that regulatory control over traffic patterns is not a sufficient government interest to qualify as a property interest under the mail fraud and the other statutes they were convicted under. So essentially, government interest in regulatory activity isn't a property interest for the government fraud statutes. After that case was issued, the Supreme Court reversed and remanded the Bladecheck convictions, asking the Second Circuit to reevaluate in light of the Kelly ruling. And in particular, whether the confidential government information they traded on in that case, in the Bladecheck case, constitutes a property interest for the criminal fraud statutes. So the Second Circuit took the case on remand, obviously. The government submitted briefs, the defendant submitted briefs, and in the government briefs, they advised the Second Circuit that they should reverse the criminal fraud convictions based upon the Kelly issue, that the confidential government information didn't constitute a property interest.
Even the 1348
I'm sorry?
Even the 1348 charge, right?
Even the 1348 securities fraud charge. They asked that the Second Circuit upheld a conspiracy charge, a conspiracy to defraud the government, but not the 1348 charge. Many commentators thought this was to sidestep having the Second Circuit address again, or having the Supreme Court address whether a personal benefit needs to be shown for 1348 criminal securities fraud conviction. So that issue still is there. It's not going to be heard likely in this case because the government walked away from that theory, but somewhere the prosecutors are going to charge 1348. It's a much easier statute to convict under than Section 10B. So it's going to be charged. And there's going to be a conviction. It's going to go up to the whatever circuit the case is heard in, and to the Supreme Court to decide whether a personal benefit needs to be shown under Section 1348 for criminal securities fraud conviction.
Yeah. Is that now a precedent, or is it technically no longer a Second Circuit precedent? I mean, we're kind of splitting hairs here, but I
Yeah.
think it's important.
Well, the Supreme Court reversed and remanded, so I don't think the Second Circuit, the original Second Circuit opinion, has any merit, any precedential value. It's still, the case is still going to be argued on appeal because there's a portion of the conviction still the government is seeking to affirm. But I don't know if the court will address the personal benefit issue. So it may be up to another court and maybe a Supreme Court decision in the future.
Okay. I'll disagree with you on one minor point. I don't think Sarbanes-Oxley was intended to address insider trading at all. So I think it's to some extent opportunistic to look back in hindsight and say that that's swept into this statute. But I think in Sarbanes-Oxley, they were focused on accounting fraud. And I don't think there's any indication that anybody was thinking one way or the other about insider trading. But that's a minor disagreement.
That's a great argument for the next set of defendants who have to argue this.
For sure. Erica, any takeaways from you on this? This case has been lingering now for a few years, and how important is it? And what do you see where the impact of this case?
So I agree with Tom that it doesn't have a direct impact on the SEC, but I was fascinated by the case because it potentially gives law enforcement another tool in their toolbox to hold insider traders to account. And that may still be the case, just depending on how this all works out, because I absolutely believe that criminal authorities will go after someone else. If they are successful, it may lead to more coordination between the SEC and the criminal authorities in these cases, because there may be some cases where personal benefit is challenging for the SEC and the criminal authorities may be able to go forward with this theory. I know they already coordinate closely, but it'll be interesting again, because it's just another avenue. I know that there were some instances when I was at the commission where it was just really hard, and it would have been nice to have this tool.
Yeah, and Jennifer, I guess you probably agree that the case doesn't really affect the SEC, but I remember early on, people were saying that, look, if criminal prosecutors can get around the personal benefit test, there may be enough cases where the U.S. Attorney's offices might displace the SEC as the primary enforcer of insider trading rules. And I don't know, do you have any thoughts on that?
I guess I just go back to the practical reality, which is in these ring cases, there's usually going to be some kind of criminal investigation. And as a result, there's probably going to be some kind of cooperator and at least someone able to speak to some kind of relationship, maybe that fits within Salman, maybe not. So I do think this is a unique fact pattern. Unfortunately, I can't really comment beyond that because it is pending litigation. But I just think in terms of continued SEC enforcement in terms of the rings based on tipper-tippy and personal benefit, I don't think that this is really going to change the way that we do cases, regardless of how the case turns out.
Yeah. Before we end, Eric, I want to go back to you. You mentioned that insider trading legislation that I think passed a little over a year ago in the House and didn't really go anywhere in the Senate. Do you have any insight on whether that's going to be revived? I mean, the political climate seems to be right now as good as it ever has been to do something like that, but I haven't seen any evidence that that's sort of a priority of the current Congress.
I have not heard it's a priority, and the world sort of changed since 2019 when it passed the House, given that they have so many issues coming out of the pandemic and the like. So if it is something that they take up, I don't think it will be for a while.
Okay. Well, thanks to the panel. I see Bruce is here, so that means our time is up, and I'll turn it back over to Bruce.
Thank you, Russ. Hey, great job. And Erica, Jennifer, Tom, thank you so much for joining us. Terrific.